Thank you, everyone, for attending the webinar today on a topic that we hope will be beneficial to you, dealing with particular contract provisions. These are 15 contract provisions that we think are really important for you as a general contractor to consider when you're entering into uh, construction contracts with the prime contractor, known as the prime contract, or with your subcontractors. And the purpose of the presentation is in part to um, make your projects more profitable and more predictable by understanding how these terms work and what they mean, and how you can use them during the course of your project. Uh, each of these provisions are important, but it's not an all-inclusive list, as you probably we can't cover every single uh, contract provision that you ought to be keyed in on, but these are 15 that we think you should focus on. The next slide provides a list of those 15 provisions. I'm not going to review each and every one of them, but we're going to divide this presentation up in segments, and the first portion of the presentation will be mine, which will be the first 5 on your list. And let's start with contract documents. And what we've tried to do with this presentation is give you a perspective of a broad perspective, and then how it relates to the provisions in your prime contract and how it relates to provisions in your subcontract with your subcontractors, and then give you an example from the AIA documents or other contractual examples to demonstrate the point. When it comes to contract documents, it should go without saying that you need to read them. You need to understand what's in them, and you need to make sure that they are signed by all of the parties. We've been involved in litigation where, lo and behold, we get involved and we don't have a contract that's signed by any of the parties, or is only signed by one. So it seems basic, but make sure that you have a fully executed copy of your prime contract or your subcontract, and don't let it sit on the shelf once you've signed it. Take the time to periodically review it. Hopefully you have someone on the project that is charged with understanding how the prime contract provisions work, how the subcontract provisions work. You also need to know what documents comprise the contract. Try to avoid conflict and ambiguities in the agreement as you're negotiating it. It's best to make the agreement as clear as possible on the front end, so you're not litigating it on the back in terms of what was meant by particular provisions. Keep in mind that ambiguities are going to be construed against the drafter, and there are certain ways that you can deal with that in a contract by having the right contractual provisions to make it neutral and that it's not construed against the drafter. But keep that in mind, that as it relates to the prime contract, if that language doesn't exist, then those ambiguities in all likelihood are going to be construed against the owner as the party that probably drafted the agreement, and similarly they're going to be construed against the general contractor and the subcontract, because that's probably who drafted the subcontract agreement. The two sides of the ledger here are just for things to keep in mind, whether you're negotiating or working under the prime contract, which is the owner contract, or the subcontract. So we talked about knowing your contract, reviewing it periodically. You might want to also have a summary of the key provisions as a cheat sheet during the course of the project, like the provisions that we're going to talk about today. That way you've got it there. You can refer to it periodically during the course of the project. The contract documents also need to have a list of all the documents that comprise the agreement, and make sure that it's got all the modifications, and that the plans and specifications, to the extent they are referenced as contract documents, those are dated, and those are the ones that are actually referenced in the agreement. We've seen circumstances where the plans and specifications that are listed in the contract as contract documents have a date on them. Nobody has those versions. So it just creates issues there. So Make sure you have all of the contract documents in one place, whether it's for your subcontract or for your prime contract. And keep in mind, whether you're negotiating the prime contract or a subcontract, that most good contracts have a merger and integration provision, which means that anything that you do leading up to the signing of that agreement that's not included in the agreement is not going to be part of the agreement. So keep that in mind. When it comes to the subcontract, make sure if that subcontract incorporates the prime contract, that the subcontractor is provided a copy of that. And make sure that you have what's known as flow down provisions in your subcontract, so that your subcontractor is obligated to assume the same obligations and rights as you do as the general contractor in your prime contract. These are some examples from the AIA construction documents, and you can see in the owner prime contract example, it lists as contract documents the drawings, the specifications, and addenda. And then you'll see in this variety of a subcontract, there is a incorporation by reference of the prime contract. So again, make sure that you provide the subcontractor with a copy of that prime contract. Make sure you have all your contract documents together, whether it's the prime or the sub, so that you can easily reference them during the course of the project. The other thing that I'd mention on contract documents to be careful of is a lot of times we'll see the proposal, whether it's from the subcontractor to the GC or from the GC to the owner, incorporated into the contract as a contract document. Be very careful with that. Want to make sure that they are consistent. Typically they're not. So better practice would be to not include the proposal, and whatever the parties agree to in that proposal just gets incorporated and included, into the operative contract, rather than calling it a separate contract document. Scope of the work. This is probably one of the most basic tenets and perhaps one of the most important provisions in your contract. It's imperative to know what it is that you as the general contractor are required to do on a project and what your subcontractor is required to do. Obviously, the scope of work forms the basis of the performance. Give some consideration to whether you want to have an addendum that more specifically spells out the scope of work to be performed, rather than just something along the lines of defining the work and saying it's going to be performed in accordance with the construction documents. Specificity here is great. The more specific, the better. Do your best not to leave any gaps in the scope, because that ultimately will likely lead to disputes and possibly litigation. So again, another slide that kind of gives you an idea of what to be looking out for in the prime contract and in your subcontract. It's goes without saying that whether it's the prime or the subcontract, make it as specific as possible. Make that scope of work specific, so there aren't any disputes on what you or your subcontractor was supposed to do. You want to avoid words in the prime contract like reasonably inferable from the plans and specifications, or that you're going to perform work in strict accordance with the contract documents using the highest degree of skill. Those are things that you don't want to include in your prime contract. Conversely, if you can include them in your subcontract, that would be preferable, because it puts the burden on the subcontractor to go above and beyond just what they see on the plans and specifications. You also want to, when it comes to the subcontract component, we want to make sure that we have language in it that requires the sub to perform its scope of work in full and strict accordance with the contract documents, as well as in connection and in compliance with the applicable construction schedule, and in cooperation with all the other trades that are out there. keep in mind that you're probably going to see a provision in the prime contract or a subcontract that requires the parties to perform work that's free of defects and in a good and workmanlike manner. That's pretty standard language that you'll see in both types of contracts. In terms of the scope of work from the AIA documents, this is an example of Article 2 and Article 9, which, as you can see from the prime contract example, it's pretty vague here. It refers back to the contract documents. Again, specificity is key here. If you can include an addendum that spells out the scope of work, whether it's in the prime contract or the subcontract, strive for that. Next slide deals with payment. Everybody wants to get paid, of course, for the work that they do. And most good construction contracts will talk about what's needed in order for the subcontractor or the general contractor to be paid, whether it's progress or partial payments during the course of the project or final payment when the project is completed. Another thing to keep in mind is what happens and look out for is what happens when the payments aren't made. Does the general contractor get to suspend performance until that payment is made, or similar to a sub get to suspend performance? Be on the lookout for those things. And certainly as the general contractor, if you're not getting paid, you don't want to be required to continue to perform work. Similarly, you want the subcontractor to continue to get paid if you're not getting paid and you're continuing to work. So again, another compare and contrast slide with the prime contract and the subcontract. There typically are procedural and documentary requirements for payment in good construction contracts. They will run the gamut of course, requiring pay applications and talk about when the pay applications need to be submitted, to providing lien and bond waivers and lien and bond waivers from both the general contractor and the subcontractor, to any other requirements that the owner or lender may have in order for the general contractor to get paid. Try to avoid agreeing to language that allows the owner to require whatever documents it deems necessary in order for you to get paid. It's better to spell all of that out, exactly what's needed in order to get paid. That will be a function of what the owner needs and likely what the lender is requiring. So make sure that you understand, as the general contractor and the prime contract, what it's going to take to get you and your subs paid. Another item in the prime contract to give some consideration to is a statement requiring the owner to provide confirmation periodically during the course of the project that it has sufficient funds to make payments to you. Not just a provision that requires them to provide that information at the beginning of the project, but periodically during the course of the project, so you know that there are sufficient funds to get you paid. As the prime contractor, as a general contractor in the prime contract scenario, if you aren't paid timely, then there needs to be a provision in the contract that allows you to suspend and or terminate work on the project. Similarly with the subcontract provisions, there needs to be some procedural and documentary requirements for them to get paid. It should be consistent with what the prime contract requires of you vis-a-vis the owner-general contractor relationship. The other thing that is important to include in your subcontract, to the extent you can, is a pay if paid provision. And there's a difference between a pay if paid and a pay when paid provision, and I won't go into the details of that right now, but you need to have something in your contract with your subcontractor that shifts the risk of payment from the owner to the sub versus from you to the sub, because if the owner isn't paying you, then you should have language in there that you have no obligation to pay your subcontractor. So if at all possible, you want to include a valid and enforceable pay if paid provision in your subcontract.
So this again is the standard payment provision in the AIA contract documents. Most of you are probably familiar with progress or partial payments. This is the progress payment during the course of the project. What's going to be required in order for the general contractor or the subcontractor to get paid. Make sure that you understand all the things that you need to do to get paid by the owner, and similarly make sure that you're getting everything from your subcontractor that not only you're requiring in that contract, but also what the owner is required, so it doesn't hang up payments to you and then subsequently to the subcontractor. Next slide. This is a final payment provision from the AIA, talking about what it takes to get final payment from the owner and from the general contractor. The other thing to keep in mind in the payment portion of the provision, the subcontractor, the prime contract provisions, is what are we doing about retainage? How much is going to be withheld during the course of the project? How much is going to be held at 50% completion, 75% completion, and along the lines all the way up to substantial completion? Obviously, as a general contractor, and to the extent that you can get an owner to agree to 0% retainage, fantastic. Not probably going to happen, but if you don't ask, you don't get. But it certainly, there ought to be some reduction in retainage during the course of the project, whether it starts at 10 and goes to 5 and ultimately becomes 0 at some point. You should give strong consideration to negotiating that retainage reduction during the course of the project. Next slide deals with extra works. Most of you know that as change order work that's not part of the original scope. It can take various forms, whether it's a change order, whether it's a change directive, but it's important to understand, what does the contract say about how extra work is to be documented, how is it going to be paid, when is it going to be paid, and what do you have to do to ensure that the extra work that you're doing is recognized and paid for by the owner, and what is the subcontractor, what are you requiring the subcontractor to do in order to have a valid claim for extra work. Many contracts that we review have a provision that the change order extra work has to be written in a writing signed by at least one of the parties, typically by both parties as it comes to a change order. But does that mean that the parties can alter that course of performance, that course of dealing, such that change order work is not being memorialized and signed? And the answer to that is yes. And so you want to make sure that you don't fall into that trap where, notwithstanding what the contracts say, the parties are operating under something quite different. And it doesn't make that much of a difference if we're talking about one or two small change orders, but in projects that we've been involved in where there was a course of dealing where change orders were not being signed, or the provisions were not being followed, the claim ends up being a very large one. And then, as you can imagine, one party is saying we never agreed to that, and the other party is saying yes, you did, because you agreed to all of these orally rather than being in writing. Change orders can take the form of additional time and or money. It's all about, these are mini contracts, and so you need to pay close attention to what it is the subcontractor is asking for, and conversely what you're asking for from the owner. So when it comes to the owner side of this extra work, there's probably going to be something in the contract that requires a signed change order prior to completing the work. And there's probably going to be something, there should be something in the subcontract that has similar language that the parties are required to both sign and agree to what's in this mini contract, because that's what we're talking about. These change orders are just a modification to the existing contract. That those change orders need to be priced. and how are they going to be priced? Is it going to be time and materials? Is it going to be a lump sum? That all needs to be spelled out. You also want to make sure in your contract documents that you identify, whether it's in the prime contract or the subcontract, who's authorized to agree to those change orders. We've seen situations where the party that's identified, or there's no party identified in the contract, is not the one who is actually signing the change orders. So Joe Smith is the authorized person to sign change orders, where Sam Smith signs them. And so you can get into an argument that Sam Smith was not authorized to sign the change orders. So to the extent you can, spell that out in your prime contract or your subcontract, so there's no dispute later on that a certain person wasn't authorized to sign them. Everybody on this webinar understands that it's not always possible to get change orders signed as required by the terms of the prime contract or the subcontract. You're moving quick, things are happening fast, but you need to try to do your best to get it done. Maybe it's not in the time frame that the contract, the prime contract or subcontract specifies, but don't let it slip. Follow up, do the best you can, even if it's just an email. Even if it's just an email where the parties say, here's our change order, are we good to go? The other side says yes, that's better than not having a signed change order at all. So think about those things. If it looks like it's things are moving too fast to get what you need right then and there, at least get an email out and get confirmation from the other side that we're all on the same page with the change order. Another thing to be cognizant of when you're either asking for additional money from the owner or the subcontractor is asking for additional money. When it comes to the prime contract and change orders, there may be some hidden language in there. There may be some language in there that says that, by executing this change order, you have released, as the general contractor, any and all claims for any additional time or money up to and through the date that you sign that change order. That would be terrible if you have other claims and other change orders that have not been resolved. The owner is going to waive that document in front of you in litigation or subsequent to the completion of the project, or at some point, and say, look, you don't have a claim for X and Y and Z. You waived it with this change order because those claims predated that signed change order. So be careful of that. When it comes to the subcontractor and what you want to do there, give yourself the ability to issue changes by written directive with a requirement for the subcontractor to perform that work. That means that, I'm going to tell you, Mr. Subcontractor, this work needs to be performed. I'm going to sign this. We may not agree on all the terms and conditions, but you go forward with that work. We'll work it out later. Give yourself the ability to do that. Include broad release language in your change orders to the extent you can. Again, you want to minimize risk, and you want to close off any potential claims that predate that change order to the extent you can. Put in your change order that the change order, the signed change order, eliminates any claims, whether it's related to that scope of work or anything prior up and through the signing of that change order. Another thing to keep in mind, and would be nice to have in your subcontract, is the requirement that the subcontractor continue to perform work in the absence of an agreed upon change order that both parties have signed. And when it comes to delays and those types of claims, you'd like to have something, and you want to scrutinize that change order to make sure that the only thing that the subcontractor is getting vis-a-vis a change order for delays is additional time. These are some examples from the AIA contract documents, what a change directive is. From the owner prime contractor side, it's a written order prepared by the architect and signed by the owner directing a change in the work. And that can be, once that's signed and without invalidating the contractor, the general contractor, is going to perform that work. Similarly, that's the same thing applies with a change directive as it relates to your subcontractor. This is a situation where you don't have a signed change order by both parties, but the owner or the general contractor has directed the general contractor or subcontractor to perform work without a signed change order by both parties. The definition of change order taken from the AIA documents is a document that's executed by all of the parties. This is just an example as it relates to the prime contract, but it would be a mini contract that everybody's signed. And certainly you can eliminate the need for the architect to sign the change order depending on the size and type of the project. You may not want the architect involved in such an agreement, but the change order should spell out what's the change in the work, the amount of the adjustment in the contract sum, and to the extent you're looking as the prime contractor for additional time, that's spelled out in there as well. Again, to the extent you can extricate any delay claim from your subcontract with your subcontractor, we would advocate that they would get more time but not more money with a no damages for delay provision. Unforeseen conditions. This hopefully is spelled out in your contract, maybe not as precisely as it could be, but the point of this presentation is to give you some thoughts on some things that you might do to adjust and make it more specific. So most of you on the call probably know what these types of conditions are. They're unsuitable soils, they are human remains that are found on a project, all types of things that you just had no idea you were going to encounter during the course of the project. And so it's important to make sure that there's proper notice provided, that there is investigation, documentation, and to the extent there is a delay in cost impact, those things are considered. So when it comes to the prime contract versus subcontract, we want, for you, the GCs on this webinar, we want to be as broad as possible. We want to give you the best opportunity to be able to make a claim for things that you just could not predict, were not aware of during the course of the project, whether that's weather, whether that's site problems, human bones found on the project. Try to make the provision as broad as possible. Keep in mind that there's typically going to be a notice period in your prime contract by which you'd have to give notice of finding these conditions and follow those. Some contracts will spell out in very detailed fashion what that notice needs to look like. But when it comes to notices like this, you need to make sure you do your best to follow the provisions of the prime contract. There also needs to be some period of time for the owner to investigate the claim, and depending on the nature of the unforeseen condition, there's probably going to need to be some schedule adjustment and cost shifting to the owner, which will result in potentially additional time and money to the general contractor for that. But again, I can't stress enough that it's important to, as soon as possible, and certainly within the time period of the prime contract, notify the owner of what it is you've encountered. And even if you don't know how much time it's going to take or what it's going to cost or how you're going to fix it or deal with it, you need to get something out in writing to the owner notifying of the condition. As it relates to the subcontractor and your contract with them, we want to be as specific as possible there. And those unforeseen conditions need to be enumerated. It can't be, and some of you on the webinar may have seen this before, any cause outside of the control of the subcontractor. No, we don't want that. Certainly want that in the prime contract, but when it comes to what you're going to allow your subcontractor to make a claim for unforeseen conditions, it needs to be more specific than something that's simply outside of their control. That gets into a very gray area, what was in their control, what wasn't in their control. If you're in South Florida and there is a flood, well, was that foreseeable or not during the rainy season? I don't know. I wouldn't want to be guessing about that, so be specific. Similarly, you want to have the same types of notice requirements in your subcontract that you're bound to in the prime contract to give you, as the general contractor, the ability to timely notify the owner in accordance with the prime contract. And again, the flow down provisions are critical. Want to make sure that the subcontractor doesn't get any more than what you get from the owner when it comes to that type of claim. This is a example again from an AIA contract, pretty standard stuff. I'll just focus on the first couple sentences there where we're talking about subsurface or other concealed physical conditions that differ materially from what was indicated in the contract documents, and unknown physical conditions of an unusual nature that differ materially from those found to exist in the construction area that you're dealing with. Going back to the prior slide, one thing I didn't mention was you want to make sure that in your subcontract that you have something that binds or requires the subcontractor to perform a site investigation. And language along the lines of the subcontractor is required to perform a site investigation, and the subcontractor is not allowed to submit a claim for unforeseen conditions to the extent that could have been determined by a reasonable site inspection. So you want to put some burden on the subcontractor to investigate and walk the site and understand the conditions. Similarly, when it comes to the prime contract, there may be some documents that the owner provides you that ties you to the information about the site in those documents, whether they do a soil boring report or they do some sort of subsurface water flow analysis. You want to make sure that you look at those things because depending on what the contract language says, if you didn't look at those things and there's an argument that if you would have, you wouldn't have encountered or had this problem on the site, there could be an issue that those unforeseen conditions are not compensable and you're not entitled to additional time for dealing with them. At this point, I'm going to turn the presentation over.
Thank you, Joby. This is Austin. Unanticipated price increases, quite a timely topic. The industry is facing severe price increases right now and has been. And so what do you do about that? Who's going to bear the risk of the price increases? And as a GC, you've got good reasons why it shouldn't be you. Price increases are typically suffered due to delay that's outside of your control, such as the owner delaying in decision making, or force majeure issues, or the owner delaying the start of the project. Also, subcontractors should bear risk for their materials because they can lock in their prices early. They can and should. They should buy out their materials as soon as you issue their subcontract. How do we do that? With the owner, you would like an open-ended entitlement to recovery for price increases. Any price increases that you suffer, you are entitled to pass those on to the owner. Well, the owner may balk at that, and that may not be acceptable as an open-ended entitlement. So one solution to consider is an escalation clause with a trigger. define what amount or what type of price escalations are recoverable and what triggers that right. For example, you could say if the prices of any material or labor increase by X percentage, then you'd be entitled to recover that from the owner. Another solution is make the owner directly obligated to purchase materials on its own. That way, if the prices go up, the owner has to pay them. With your subs, you know, if it's fixed price subcontract, the sub is generally going to be on the hook for price increases. In your normal fixed price contract, you may not deal directly or explicitly with price increases, and it's just implied because it's a fixed price. However, in today's environment, that could lead to arguments during the project, and you can avoid those. You head them off at the pass by explicitly and directly addressing price increases in your subcontract, and make it clear that the sub is at risk and is not entitled to a change order for increases. Here's at the top on this screen, there's an example of one way you could deal with it with the owner. This would be an escalation clause with a trigger based on a percentage of that increase. However, this example is still a bit vague and is subject to dispute. For instance, how do you prove the increase? What are the mechanisms that you employ to prove your entitlement? Also, a trap for the unwary to be aware of is if you're limiting your price increase escalation only to a specific type of material, then you're excluding your entitlement for other types of materials. For example, if in your prime contract you say that the owner is at risk for increases for lumber material, well, then that means by exclusion that concrete increases would not be recoverable. On the bottom of the screen is a snippet from the AIA contract, and it's just there to point out that the AIA is silent with respect to price increases other than this tax provision. It explicitly only addresses new taxes and price increases for taxes. The next topic that should be addressed in contracts is delay. We've spoken about delay previously. Joby covered it under change orders and other topics, so we won't spend a lot of time here. But who is at risk for the time and money associated with the delay? You need to think through both from a time and money perspective and address that in your contract. No damages for delay clause are quite obvious. Actual or liquidated damages is a topic worth considering. And I would suggest that you don't have a knee-jerk reaction to LD clauses. They can be your friend if negotiated appropriately. And in the alternative, if you don't have an LD provision, then you're open to actual damages. And what are those actual damages? And those will have to be proven later. And at the end of the project, you won't know the magnitude of damages that you may be facing. And it could be more than what you could have negotiated in an LD clause. Force majeure is on this slide, a relevant topic, but we'll come back to that in our next section. So in your contract with the owner, well, and with both the owner and the sub, you need to think upstream claims and downstream claims. Your claims for delay to the owner, and the owner's claims for delay against you, and equally with the sub. So make sure you're thinking both upstream and downstream. In your prime contract, you should say that you're entitled to time and money for delays caused by others. You'd like to be kind of broad there. Don't get specific to limit the types of delays that are recoverable. On the flip side, for delay that you may cause, you should have the owner, if you can, waive all delay damages against you. But if that's too strong and the owner doesn't accept it, maybe the owner waives consequential damages. And then if that doesn't work, another alternative would be waive all damages except for liquidated damages. And then again, you liquidate or pick the amount of what the delay damages are going to be. So you're not arguing about other damages caused to the owner. With your subcontractor, give the sub the right to additional time, but not additional money, and have your subcontractor waive entitlement to time and money if you can, but if that doesn't work, limit it to only what you as the GC can recover from the owner. Also, make it a requirement that the subcontractor provides you timely notice so that you can pass on that claim to the owner. Here's two examples, or one example of the AIA provision, how the AIA deals with it. It says you are entitled to time for delay, but only that you may be entitled to money. I would suggest that in your prime contract you make it more explicit that you are entitled to delay damages. Force majeure, relevant topic in today's industry. We've all been talking about it, and essentially it excuses performance of the contract, meaning something's going on, it's outside of your control, and you're not able to continue performance of the project, so it causes delays. Could also cause price increases as materials prices are escalating and labor prices. So as the GC, what should you not be responsible for? When should your performance be excused? With the owner and the prime, you want it broad. You start with a very broad, all-encompassing language, such as any cause outside of your control. But then you also want to be very specific, and you want to list out as many specific instances as you can. Another thing to consider is time and money. Most force majeure clauses I see only address time. They excuse your time of performance. But you can also address money. Price increases may occur because of these force majeure events. So you should write that into your prime contract if you can. On the flip side, with your subs, you don't want a force majeure clause. You want to make your sub liable, responsible for time and money, even for things outside of its control. But if that's not acceptable by your sub, then you would want to provide a very limited force majeure clause. Also, you would want to add stringent notice requirements that require the sub to give written notice in sufficient time that will allow you to turn around and pass that claim on to the owner. Here's an example that has a list of specific events, and then it closes with the broad catch-all language for anything outside your control. Also, you'll see at the bottom that it includes entitlement to recovery of time and money. All Our next topic that should be covered in your contracts is claims for additional time and money. Joby covered this somewhat in his prior slides, so we'll breeze through it. But the issue that you can address in your contract is, what constitutes a claim, and then when a claim does arise, do you have to provide notice? When do you provide notice? How do you provide notice? Can it be written or verbal? What type of detail do you need to include in that notice? And you'll see on your screen, we've previously done a robust presentation on this topic. So if you'd like to learn more, I would direct you there. In your prime contract, you don't want to tie yourself down to tight deadlines. Ideally, you have no deadlines on when you can bring your claim. You don't want language that waives your claim if you don't provide timely notice. And you want your notice to be very simple, and you want it to be verbal or in writing. An email, a meeting, a phone call, any of these things that, where you told the owner that whatever occurred could result in a claim for money or time. With your subcontractor, obviously you want to do the opposite. You do want very clear, short deadlines that the sub has to provide you notice of its claim. And the sub's claim to you needs to be in writing and contain certain data that it substantiates its claim. And, and that allows you to then turn around and pass that on to owner. So that's all information you need. Here are some examples from the AIA. And with the owner, you have 21 days after you recognize the claim to put the owner on notice. Also, be aware that you have to include the architect or initial decision maker on your notice to owner. And courts do strictly construe these types of contract provisions. And if you fail to do what your contract says, you may have completely lost your claim. Next, I want to talk about termination and suspension. If your contract does not have a termination provision, then a party may only terminate for a material breach. And that's important to be aware of, because that's something that you would have to prove. If you're going to terminate properly, you need to be prepared to prove that it's a material breach. And if you terminate improperly, the other party may have a claim against you for improper termination, and the damages, and you may have to pay whatever damages they incurred due to your improper termination. Here are some ways to deal with termination in your prime contract and subcontracts. With the owner, you may allow your owner to terminate for convenience, meaning, without cause. You didn't do anything wrong. The owner just wants to terminate and stop the project. And that may be okay, but in that instance, the remedy that you should be provided is recovery of your anticipated overhead and profit. All of the profit margin that you intended to make as if you had completed the project as a whole, so your total profit for that project. And that's, can be a very reasonable ask because you'd committed yourself and your team, your forces to that project. And now where are they going to go? Well, how are you going to use them on other projects? You may not have been bidding other projects. And so there's various rationale why you should be entitled to that. Then you should also address how the owner can terminate for cause. You should require the owner to provide you with written notice and a lengthy opportunity to cure. So whatever the owner thinks you've done wrong, the owner needs to explain that to you in a formal writing, and you should be given a lengthy, reasonable amount of time to cure it. Your ability to terminate, you need to address that in your prime contract. You may put in there that the general contractor can terminate for convenience, but I would say that's not very common. Termination for convenience you typically see only as a right of the owner. When it comes to termination for cause, you want to make it as easy as possible on yourself. You want verbal or written notice. You don't want to give the owner a long opportunity to cure. When the owner's doing something wrong and you're ready to terminate, you're ready to get out now. So don't allow a lengthy cure time for the owner. And then there are some defaults, some reasons why you would want to be able to terminate immediately. If the owner is insolvent, is just one example. There's no reason for you to wait or to allow a cure period when it just doesn't make sense. And when you think through your termination provisions, not only is the type of notice, the time of cure, and the types of defaults something you should consider, but also consider what your remedy is. What if you're terminating, what do you get? If the owner's terminating you, what do you get? Overhead and profit, costs due to termination. There could be costs that arise solely because of the termination that aren't in your contract price. Are you entitled to recover that? And if the owner terminates you, or even if you terminate, does the owner have to pay you right away? Or can the owner, if the owner owes you money, can it hold that money and keep it till the end of the project and set off any amounts that the owner incurred to finish the project? Of course, you would want the owner to be obligated to pay you right away and not withhold monies. With your subcontractors, it's somewhat the opposite. You want to be able to terminate your subcontractor on short notice. You want it to be easy to terminate your subcontractor. This slide addresses suspension, which is slightly different than termination. With the owner, you do want to explicitly address your rights to suspend work, and you want to be able to suspend work immediately upon non-payment by the owner. If the owner's failed to pay you on time, you want to be able to stop, walk off the job until the owner pays you, and then you'll come back. And then there's other instances such as a government order, if the building department orders you to stop work, or some other emergency arises, you want to be able to stop work. And also address that if you do stop work, if you suspend work, that you're not going to become responsible for any cost or time that arise because of that suspension. And even better than that, you make it such that you're entitled to recover for any time or cost that you incur because of that suspension. With the subcontractor, you don't want the subcontractor to be able to suspend work on its own. You want to be able to force your sub to continue working even if the owner hasn't paid. But you do want to be able to force the sub to suspend work for any reason. And if you do suspend the work, that you're not going to become liable to the subcontractor. Here are some examples from the AIA. I'll just point out a few things. Termination of the owner of the prime contract by you as the GC requires 7 days notice to the owner and architect. And your anticipated overhead and profit is recoverable with this language in the standard AIA. If the owner tries to terminate you as the GC, section 14.2, which is not on the screen, does a decent job of protecting you as the GC. And The basis for termination for cause requires repeated failures by you or substantial breaches by you. And that's examples of types of language that you'd want to put in there to protect yourself. So, merely one breach by you, shouldn't be enough for the owner to terminate you. And you can fix that breach and move on and continue with the project. Our next slide, I'm going to pass the mic to Joby, back to Joby.
Thanks, Austin. I'm going to try to move things along a little bit, conscious of your time here, and so may spend a little less time on some of these slides. But next slide that we want to talk to you about is indemnity. That's a topic that comes up a lot when we're looking at contracts for clients, and what does it do? What does it mean? What do we agree to? How broad should it be, et cetera? So in Florida, there is a specific statute that covers indemnity obligations under for construction projects. It's Chapter 725.06. As a general concept, indemnity is a risk-shifting mechanism that requires one party to a contract to assume responsibility for losses or damages incurred by another party under particular circumstances. And the party agreeing to accept the responsibility is the indemnitor, and the person that is being held harmless or being indemnified is the indemnity. I would suggest that in context of any indemnity provision that you're looking at, whether you are looking at a subcontractor, prime contractor relationship, or in the prime contract itself with the owner, pay close attention to what the parties are required to indemnify for. If you're just going to indemnify the other party for your bad acts, no problem. When you start requiring somebody to indemnify you in whole or in part for your bad acts, there are a lot of bells and whistles and hoops that you have to jump through to make sure that that's enforceable. So let's talk about the different sides of the fence here when it comes to the prime contract or the subcontract. With respect to the prime contract, you want to, as the general contractor, limit your indemnification obligations to third-party claims. Someone gets injured, someone brings a claim, it's not the owner, it's somebody else for personal injury or property damage caused by your negligence and your percentage of that negligence. That's key because you don't want to own all of it if you only caused part of it. Try to avoid any broad form indemnity where you're agreeing to indemnify the owner for bad conduct by the owner or its agents. 725.06 will give you a good idea. If you've not read that statute, it's very short. Give you a good idea of what you need to have in your contract if someone is requiring you to indemnify them for their bad acts, the owner, that is. And similarly, if you're trying to hold the subcontractor to that same standard. Make sure that your insurance policy coincides with your indemnity obligations. That would be something that you would want to not only consult with your lawyer on, but also your insurance agent. Many of you may know the difference between indemnification and defending and holding harmless. There is a difference. Defending is just simply saying, I'm going to defend you if there is a claim that triggers my indemnity obligations. It doesn't necessarily mean that I have any obligation to pay you any amounts that you are claimed to owe. So that duty to defend is, in the insurance context anyway, is much more broad than the indemnification, the payment obligation, but there is a difference. The takeaway there is make sure that your subcontractor and the subcontract requires the subcontractor to indemnify, defend, and hold you harmless from any of those types of claims. And again, making sure that your you're compatible with the requirements of 72506 if you're asking that subcontractor to indemnify you for anything that you cause. These are some sample indemnification provisions in the AIA contract documents, and I'll just caution you that I don't think that the provisions here without more are enforceable under Florida law, because you have a broader language in here that I don't think complies with the 72506. When you start talking about arising out of or resulting from language, it's a little bit more broad. And so if you're looking at this provision, there are some other bells and whistles required by 72506 that arguably you would want to include to make sure that these provisions are enforceable. and importantly, you want to have some indemnification obligations from the prime contract standpoint with the owner. You want to try to make it as narrow as possible. And from the subcontract perspective, you want to make it as broad as possible. And when you start broadening it out to something more than just what you cause or the subcontractor causes, that's when you need to make sure that you look at the statute, make sure it complies. Limitation of damages. This is an important one, and many subcontracts and prime contracts have some form of waiver or limitation of damages, but the damages that you can, or the owner can, or that the subcontractor can incur, on a construction project, run the gamut. An owner can have damages because it can't open the project on time, so as a lost profits claim, or maybe it's a school and they have students that are going to be in the school and they can't put them in the school, so they've got to rent temporary facilities, and lots of different things that can happen and damages that can result if a project goes wrong. So you want to, from the perspective of just overall understanding of damages, there's a lost profits claim, there's a loss of use, there could be reputational damage, there could be interest and finance charges that the owner could blame and call the general contractor liable for if the project isn't completed on time. So you need to pay close attention in the prime contract in terms of what damages you're entitled to as a general contractor, and similarly what the owner is, and try to limit and tighten up what damages a subcontractor could claim in your subcontract. So from the owner side, and the way I look at things in a large construction project is there's probably more of a consequential damages claim that the owner can assert if the project isn't completed on time, or it's not completed correctly, or there's defects in the work. You try to, and because of that, you try to have a mutual waiver of consequential damages in your prime contract, or if not, a cap on that amount, meaning a monetary limitation on what those damages could be. Similarly, you'd like to have a exclusion as it relates to liquidated damages. Those are the dollars that the owner is going to claim day for day in damages if the project is not completed on time. Those are typically going to be the sole delay damages that the owner is going to be able to recover in the event the project is delayed, and but you need to pay attention to those. And if the owner, from my perspective, if the owner is going to demand that you agree to a liquidated damages provision, as a general contractor, you should not agree to a no damages for delay. It's kind of quid pro quo. If you're going to ding me on the delay that I cause, I'm going to ding you on the delay that you cause, and so I don't just get time, I get money. So anytime I see an LD provision in a prime contract, I want to make sure that my client also has the ability to get paid for delay damages that the owner caused. It's only fair. With respect to the subcontract, those terms whether there's a mutual waiver of consequential damages or not, you should try to match those with the prime. Now, if you can get the subcontractor to waive its consequential damages, and as the general contractor, you're not waiving that, great. I've done that before. But to the extent you can't, again, try to negotiate a cap on the subcontractor's damages of any kind. This is a sample provisions from AIA contract documents that talk about mutual waiver of consequential damages. It's a mutual waiver, both parties, whether it's the owner and the general contractor in the prime contract scenario or general contractor and subcontractor. The purpose of this is to have a mutual waiver of consequential damages by both sides. And so pay attention to that. Give some consideration to whether or not you think that's a good thing to have. I think in the prime contract scenario, a mutual waiver of consequential damages probably benefits the general contractor much more so than the owner, but need to be paying attention for those limitations of damages provisions, especially if there is a cap on damages somewhere in the prime contract or subcontract. This is an example of a cap on damages provision. You can see that there is a dollar amount that the parties would agree to, and sometimes, as this one does, it talks about the limitations of insurance or amounts of insurance. I would suggest that if you're negotiating the contract, the amounts available under the insurance and the limits of insurance are maybe two different things. You might want to be more specific, and if you're going to limit it to a dollar amount, it would be the amount covered, the dollar amount set forth in whatever policy you're referring to. This dovetails into the insurance requirements. Lots of insurance involved in large construction projects. Could be commercial general liability, typically workers' comp, E&O, professional liability insurance. We want to make sure, first of all, review your contract documents, make sure you know what you're required to provide as the general contractor, that you can get that coverage, that you can get the policy and endorsements that the owner is requiring. And a lot of times those same requirements flow down and are referenced in the prime contract that your subcontractors are required to provide. So make sure that you're looking at both the prime and the sub and making sure that your sub can get the coverage required and they provide it. You want to, I'll go back to that slide, please. You also want to make sure that you're working with your agent to ensure that the work that you're actually doing is not excluded by the policies. I know that sounds weird, but I know of examples where a stucco subcontractor is doing work on a multifamily project, and lo and behold, their policy excludes coverage for stucco work on multifamily projects. And believe it or not, there was a stucco problem and there was no coverage. So be aware of those things. You're requiring your subcontractor to provide you with insurance policies. Make sure you take a look at them, have somebody look at them, make sure there aren't any exclusions in there. Just from real quick on from the owner and the subcontractor side of the fence, with the prime contract, you want to obviously work with your broker, make sure you can meet the coverage levels, coverage limits. You want to make sure that your indemnity obligations under their contract are included and covered by your CGL policy. There's going to be on a large project, there's going to be builder's risk. Who's going to provide that? What's it going to cover? Make sure that you review the contract to make sure that the coverage required, if the builder is providing it, rather than the owner procuring it, that you get what's required. When it comes to the subcontractor, get the policies. Don't just rely on the certificate of insurance. That's not insurance. I've had situations where we got a certificate of insurance from a subcontractor. The client thought that it was an additional insured. The certificate of insurance was not accurate, and we did not have additional insured coverage, so that was a problem. So make sure that your subcontractor provides copies of all the required policies and endorsements before they start working on it. Dispute resolution. Any of you that have been involved in litigation on construction projects knows that that can be a very painful process, very time-consuming, very expensive process. So it's important to make sure that you spell it out in your agreement so you're not litigating that issue. A lot of times people are litigating who gets to decide the case, where it gets decided, what law is going to apply, all of those things that you don't need to be paying your lawyer to argue, and you can cover in your contracts on the front end. There are different types of dispute resolution mechanisms: pre-suit mediation, during suit mediation, arbitration, and litigation. The dispute resolution mechanisms in a good construction contract will spell out start to finish who, how, where a dispute gets resolved. And any of you that have worked with the AIA documents know the IDM, or the initial decision maker, who's involved in the dispute resolution process. That's unique to the AIA contract forms. You may have a mandatory pre-litigation mediation requirement. And then there's obviously the arbitration and litigation sides of how the dispute ultimately gets resolved. From an arbitration perspective on the prime contract component, really important to make sure that there's something in the contract, your prime contract, that allows you as the general contractor to bring other responsible parties into the arbitration. Oftentimes there is language in the prime contract which does not allow you to do that, and that creates a problem because all of the parties are not at the table, and it forces matters to get relitigated and adds expense, and in some instances is a bar or a real inhibitor to getting the case resolved because not everybody's in the case. So, for example, you want to have the ability, if you're sued by the owner in arbitration, you want to have the ability to bring in your subcontractor or whoever it may be that you think is responsible for the problem, and you don't have to wait until that arbitration is over to deal with that issue. Similarly with the subcontract, going back to the flow down provision and making them consistent, you certainly don't want to have an agreement in your prime contract that says you have to arbitrate claims in Hawaii and your subcontract says that you litigate claims in Jacksonville, Florida. That's not good. So you want to make sure that those types of provisions are consistent, prime contract to subcontract, and also include pass-through provisions that address how the subcontractor's claims, to the extent they only relate to the owner, are going to get resolved, who's going to control the settlement, who's going to control the litigation, and finally, when it comes to subcontract agreement, language that says that the subcontractor is only going to recover from the contractor if the contractor recovers from the owner. That's critical. Let me go back to that slide real quick, Austin. Just one note on arbitration versus litigation. Lots of clients over the years have said we like arbitration, we hate arbitration, we like litigation, we hate litigation. I just give you a couple of pros and cons on them. Arbitration is, in my view, as expensive in big construction defect cases or big construction bond cases or any sort of construction related case, because you're going to have arbitrators that you're paying and filing fees that you're going to incur that you wouldn't if you were in litigation. You don't pay a judge to decide your case. You pay a nominal court filing fee, but you don't have all the other fees. So you've got that component, which is expensive, can be expensive. You have the private nature of an arbitration, which is good, and you also have seasoned either construction lawyers or practitioners in construction that know what you're talking about. Whereas your average person, if you start talking to them about cladding and window installation or critical path delays or name the dispute du jour, they're not going to understand what those things are for the most part. So, and that's a good thing about arbitration. Litigation, it's you're going to have a judge, you're going to have a jury that may or may not be good. You're also not going to be paying for some of the things that you would be paying for in arbitration, and you have rules in litigation. You have court rules, you have rules of procedure, you have rules of evidence, you have the ability to appeal decisions that you don't like. You don't have that ability unless you write it into your contract in the context of arbitration. So they both have pluses and minuses, but the notion in big construction cases that arbitration is less expensive and faster, I'm not sure I agree with that. So just keep those things in mind when you're deciding whether or not you want an arbitration dispute resolution provision or a court resolving your dispute. Attorney's fees, I'm just going to mention real quickly. We'll breeze through this slide. You ought to have a prevailing party attorney's fees provision in your contract. Otherwise, unless there's a statute that allows for attorney's fees, if you get into a dispute, you're not getting attorney's fees. It's a general matter. The contractual provision relating to attorney's fees needs to be very specific so that not only do you get your attorney's fees if you prevail in the case, but you also get your attorney's fees for arguing about, after you've won the case, how much you are owed in those attorney's fees. If you don't have that language in your contract, there's an argument that you don't get attorney's fees for fighting about attorney's fees, which seems strange to most people that you talk to about that issue. But the garden variety attorney's fees provision in a contract that we see doesn't get you all of the relief that you might be entitled to as it relates to recovery of attorney's fees. And keep in mind, at least in Florida, that even though you won on certain issues in the case, a judge could determine that there was no prevailing party and nobody gets attorney's fees. So I always caution clients that, yes, we have a prevailing party attorney's fees, and yes, the judge could award them, but he or she might not. So just real quick, ought to have the fee provision in there, should include fees for litigating the amount of fees, not just your entitlement to them, not just determining that you're the prevailing party. You want to have appeals fees and post-judgment collection fees included in your prevailing party attorney's fees provision, whether it's in the prime contract or in the subcontract. This is just an example of a prevailing party attorney's fees that we like, and is very encompassing in terms of all the things that you might be dealing with. So this one talks about sort of middle of the road there, incurred in such dispute prior to, during, or after, including appeals, bankruptcy, prejudgment collection, etc. And so it gives you the ability to get your fees during post-judgment collection as well. So this is a very broad one that allows you to get attorney's fees for lots of different things that go on prior to, during, and after your dispute is resolved. At this point, we'll open it up to some question and answer period. I know that there have been some questions already submitted.
Yes. We will jump into a couple of questions. I know we're running a little bit over today. First one that came in is, if the subcontract contains a pay provision, can the subcontractor still report a lien or make a payment upon a claim?
Elizabeth, I'll take that one. The answer is yes, they can. So you need to be careful of that. There's not much you can do. If your when it comes to a bond claim, if you're in Florida anyway, if you have a conditional payment bond and you have a pay if paid provision, you may be able to eliminate any bond claim, but you're not going to be able to eliminate a lien claim.
Great, thank you, Joby. I'm going to put one more. It is, even if the subcontract contains specific notice requirements, can a subcontractor still successfully assert a claim if those procedures are not precisely followed? For one of y'all.
This is Austin. Elizabeth, I'll take that one. The answer is surprisingly probably not. If the contract requires certain notice provisions and those notice provisions are not followed, there are a lot of cases out there where the contractor did not prevail on a claim. We've seen cases where there's millions of dollars at issue and the general contractor had a valid claim, but only provided verbal notice to the owner timely, didn't provide written notice timely, and the general contractor's claim was rejected by the courts. So I caution you to read your contracts, know what your notice requirements are, and follow those to a T.
Great, thank you, Austin. I think that is all of the questions that we will have time for today, and we appreciate everyone joining us and tuning into the webinar. If you have any additional questions that we were not able to answer today, you are welcome to present with or connect with any of the presenters. Their contact information is available on our website. That website is jimersonfirm.com. You're always welcome to give us a call for more info as well at 904-389-0050. As always, if you have any feedback on today's presentation, please feel free to send it to us via the link that you will receive as a follow-up. Today's event materials will also be sent to you in that email. Again, we appreciate you joining us and hope you have a great rest of your day.
Thank you, everyone.